Good morning. Good morning, everybody. Good morning. Welcome. I need to do a quick organizational moment, but didn't want to miss my 11 o'clock. So one moment, please. Welcome on in, everybody. Good to see you. Take care of this real quick. I didn't have a chance yet. Yes, working on a Saturday. Yes, but it's fun work, so it's okay. If it's fun work, that means it's all right, right? Oh, I've just got to pull this case law out really quick, and then I will be ready to go. Good morning. Yes, hello, Kristen. Hello, good to see you. Welcome on in, everybody. I'm just taking 1 minute here to organize the case law here, and then I will be able to dive on in. This should be a very interesting brief here, of course, that's been submitted by the ACLU. We don't know if it's been accepted or not yet by the court. But good morning. Oh no, you have an echo. Does anyone else have an echo? Let me know. I can try to move my mic around here if it's echoing too much. So hello. No echo. Okay. Oh dear. Oh goodness. Yeah, this is a pretty not very extensive setup here, everybody. You could see. Oh my goodness, if you could see the setup I have here, you would probably laugh. So I'm just pulling this case law out real quick before I dive on into reading through this, everybody. So today we're going to do, how am I feeling? I'm feeling great. I'm feeling very good. Had a very restful evening, so last night, which was great. So I'm doing pretty well. Although I have to say, I see some snowflakes starting to fall, so I'm not sure how I feel about that. I'm not sure if I'm ready. I'm not ready yet for snow, but I have seen a few flakes falling, so I don't know. I'm not quite ready. I know. Did the green? Yes. No, I've got it. I've got my green light. But thanks for asking. Yes, I know. No snow. I'm not ready. We usually, if we can make it past Halloween without it snowing, we're in really good shape. But I don't think that's going to happen this year. 78. Oh my gosh. I'm so jealous. I'm extremely jealous at this point. I know. I'm not ready. Oh my gosh, Arizona in the winter. Oh, wow. Dream. That would be a dream for sure. Absolutely. Yeah, the winters get to be a lot here. They really do. Oh, good morning from the Bronx. Well, good morning. Hello. Welcome on in. Welcome in, everybody. I have I will be doing 2 lives today with a break in between. So I've got 2 things to go over with everyone today. In the 60s. All right. Well, that's, still gorgeous. That's nice. Hello, Greg. Hello. Welcome. 27. Okay. Yeah, you're getting cold. You're getting cold there in Oregon. Oh my goodness. That's a lot. I'm not ready, everybody. I'm still wanting it to be fall. I'm not ready. Ooh, snow on the way. Oh, you can still, oh, nice. I love that. Yes. So welcome on in, everybody. I will be carving pumpkins tonight. So instead of doing a live tonight, I'll be doing 2 during the day today. So thank you for joining. They'll be a little bit shorter lives, but I think this format will work out for everyone. So, oh my gosh. Wow. Yes. So, yes, I'm very excited. I'm excited. If I get a chance to carve pumpkins or watch the pumpkins being carved, that's a special treat. So All right, everybody, let's go ahead and get, oh, thank you. Thank you so much. Let's get diving on in here. So last night we had gone through the government's replies to the various motions that had been filed. Now, this is the District of Columbia case, all right? So this is U.S. versus Trump. This is the election case. Oh, thank you, John. I appreciate that. Now, we went through the overview of the government that responded. Now, we had this limited gag order, we'll just call it a gag order, that was set out by Judge Chutkan in the D.C. case regarding extrajudicial statements being made, outside of court. And she had put a restriction on things regarding the prosecutor, the prosecutor's assistants and family, the defendant, the defendant's family, and court staff. Limited gag order. So the defendant had appealed. So he's got his appeal going. And in the interim, he asked for a stay, which means a pause on that order. So she did pause that order until it could be determined at the appellate court, which can happen. That's pretty frequent. We appreciate you. Oh, thank you so much. I'm glad you could be here. So the government responded with the motion last night, stating it was a very narrowly tailored order, which is what you need for First Amendment questions, for a compelling government interest, which was due process. So they're wanting to have a fair trial. Now, the response has not come back in yet from the defendant, but we did get what's called an Amicus Curiae brief from the ACLU, which is the American Civil Liberties Union. They filed a brief against the gag order with regards to the First Amendment. So that's what I'll be going through here. It's not a very long brief. It's a very condensed and concentrated into just specifically what the issues are on the First Amendment. So I will take you through this Amicus Curiae brief again from the ACLU. So let me get my sticky note going. Oh, thank you. Oh, I love the ghosts, everybody. Welcome on in. Welcome, everybody. Yes, we will definitely be seeing if we've got, we'll see how the ACLU is approaching it and if we agree or not. We will have to assess their arguments, everyone. So let me get my sticky note going here. All right, we've got an Amicus Curiae brief. Oh my goodness, thank you for that. I just love the little ghosts. They're so cute. All right, Amicus Curiae. I'm writing out my sticky note, everyone, and then I will dive on in. So from the ACLU, which isn't surprising, this is kind of what they do. So we just don't know if the court will accept it or not. Usually you need to get permission before filing a brief, but we will see. Amicus Curiae means friend of the court. So it's supposed to be, it stands for basically an impartial outside party that's not a party to the case. So these are the two parties to the case. So it's someone other than these parties who says they've got some information that can help the court come to a just decision. So that's why they filed the brief. We see this a lot in U.S. Supreme Court cases, of course. In some of our more contested cases, we can get 250 Amicus Curiae briefs for a U.S. Supreme Court case. But here we've got the ACLU brief. So just finishing up my sticky note here, and then I will dive in. So we've got U.S. v. Trump, D.C. case. Oh my goodness, all the Halloween goodness. I love it. I just love it. D.C. case. All right, I've got my sticky note going, and let me just make sure I have it placed on here. All right, there we go. So there's our sticky note, and we will go ahead and get diving on in. Yes, I've got my little Halloween theme today. So let me make sure I'm lined up here. Am I crooked, everybody? Hold on a second. Let me double check. And it looks like my sticky note is not very sticky. Okay, all right. Let's see what I can do here. Here we go. Looks good, looks good. All right. I'm going to just tape down one side of my sticky notes so it's a little bit easier to see it here because I see it's popped up. So one moment, please, as I get my technical sticky note situation. Look at this high tech. Oh, I'm so high tech. Here we go. All right. I think we're looking okay now. All right, everybody. So let me grab my writing utensil in this situation. All right, here we go. Amicus Curiae. Again, for some reason, it's looking a little bit crooked. So, yes, tape, yes. I just have to remember. Oh, innovative engineering. Oh, that's so, that's lovely. I love that. Yes. All right, here we go, everybody. So, our Amicus Curiae brief for the American Civil Liberties Union filing on the First Amendment. DC case. All right, so here we go. First, we'll get into the table of authorities. The interest of Amicus Curiae, or Amici Curiae, however you want to say it. We have our two big argument points. The order's use of the word target is unconstitutionally vague. Again, we're referring to the judge's gag order, Judge Chutkan's order. That is stayed right now, so it's paused. And then number two, any restraint on defendant's speech must be narrowly tailored to prohibit imminent threats against individuals or conduct that would interfere with the administration of justice. So we've got sub A, the First Amendment standard is strict. It's the strictest of scrutinies. And B, the October 17th order is overbroad and underexplained. So let's get into their arguments here. Here's our table of authorities. So these are just their different cases that they're citing throughout the brief. And now we'll get into the actual argument here. So, okay. Again, I'm just, for some reason, it's looking a little crooked, everybody. Is it okay? Hopefully it's okay. All right, here we go. The American Civil Liberties Union, the ACLU, looks good. Okay, thank you so much. Is a nationwide nonprofit organization that since 1920 has sought to protect the civil liberties of all Americans. The ACLU of the District of Columbia is the ACLU Washington, D.C. affiliate. Amici, or Amici, have frequently appeared in this court as counsel and amici, or amica, in cases raising significant questions about the meaning of the Constitution, its limitations on government power, and the breadth of rights it grants. Amici have also participated in many of the most consequential First Amendment cases in American history, including the 1966 Supreme Court case upon which the court based its authority to issue the October 17th gag order. So they're referring to the Shepard case, which Judge Chutkan had referred to in her gag order. Amici seek leave to file the instant brief pursuant to the rules. So again, they're asking permission to file the brief, although technically it's already been filed. So that's kind of how that works here. And this footnote here is just explaining again amici. So pursuant to local civil rule 705, counsel for amici curiae certifies that no counsel for a party authored this brief in whole or in part, and no person other than amici curiae, their members, or their counsel made a monetary contribution to the brief's preparation or submission. So it's very important. An amicus curiae means, of course, they are not a party to the case. They're an outside party. Arguments. Former President and now defendant Donald Trump has said many things. Much that he has said has been patently false and has caused great harm to countless individuals as well as to the republic itself. Some of his words and actions have led him to this criminal indictment, which alleges grave wrongdoing in contempt of the peaceful transition of power. But Trump retains a First Amendment right to speak, and the rest of us retain a right to hear what he has to say. Thus, any restraint this court imposes on defendants' future speech must be precisely defined and narrowly tailored to protect the impartial administration of justice. Respectfully, the court's October 17th gag order fails that test, and amici urge the court to reevaluate it. Doesn't get much more clear than that for an introduction. The court's use of the word target is unconstitutionally vague. In its order, the court barred defendant from making any public statements or directing others to make any public statements that target 1. the special counsel prosecuting this case or his staff, 2. defense counsel or their staff, and 3. any of the court staff or other supporting personnel, or 4. any reasonably foreseeable witness or the substance of their testimony. The entire order hinges on the meaning of the word target, but that meaning is ambiguous and fails to provide the fair warning that the Constitution demands, especially as here it concerns a prior restraint on speech. So we have a footnote number 2 here. The gag order restrains both the defendant and his counsel. Amici focus on the rights of the defendant here, in part because he's running for president and because attorneys can be restrained as officers of the court in ways that non-lawyers cannot. But amici's concerns about the vagueness extend to all who are required to comply with the order. And here we go. The vagueness doctrine, rooted in due process, ordinarily applies to legislatures, requiring the statutes provide fair notice or warning of what is prohibited by penal laws. But it also applies to court orders that carry with them the threat of punishment. Fairness demands that the law and judicial edicts avoid laying traps for the innocent and instead give the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. The vagueness doctrine has special force, whereas here government action restricts speech because uncertain meanings inevitably lead citizens to steer far wider of the unlawful zone than if the boundaries of the forbidden areas were clearly marked. The First Amendment rights of the accused require any court order restraining their speech to be both clearly defined and narrowly framed. The order's prohibition on speech that targets certain named and unnamed individuals is neither. Reading the order, defendant cannot possibly know what he's permitted to say and what he is not. Target is an inherently vague term. It can mean to make an object of ridicule or criticism, or even to affect someone by an action. In the context of the order, it could mean something as innocuous as name or identify, or something much more violent. One could target another with respect but vigorous political advocacy, or target them for physical violence or death. Context can sometimes provide clarity, but the October 17th order gives none. It does not define target to be narrowly limited to its most menacing implications, perhaps prohibiting true threats or incitement of violence against witnesses or court staff, nor does it give examples to guide defendants' behavior and the public's expectations. One of the categories that cannot be targeted is the substance of the testimony of any reasonably foreseeable witness, an unknown and perhaps unknowable range of possible topics. The meaning of target is even less clear in this application. While it might mean affect or influence the substance of such testimony, it might simply encompass merely addressing the testimony in general. Defendant cannot know which of these meanings applies, and as a result, the order risks restricting too much speech. Okay, tea break, everybody. 1 moment. All right. Should the court continue to believe that a gag order is necessary in this case, the court should rephrase its order or clarify its meaning. So now we're getting to the point here. They're not necessarily saying we can't have a gag order. What they're saying is you need to clarify the words you used. Number 2, any restraint on defendant's speech must be narrowly tailored to prohibit imminent threats against individuals or conduct that would interfere with the administration of justice. The October 17th order suffers from a second flaw. In addition to being impermissibly vague, it is impermissibly broad. Commendably, this court applied a high First Amendment standard in assessing the need for the order. They're citing the order. Finding the potential for extrajudicial statements by both the parties and their counsel pose a significant and imminent risk of prejudice. Unfortunately, the order fails to adhere to the standard with sufficient rigor and consequently bans too much speech without a sufficient explanation of how the First Amendment standard has been met in this case. The First Amendment standard is strict. The heavy presumption of unconstitutionality that attaches to prior restraints forms the backdrop against which courts must measure their own restrictions on speech in connection with the judicial process. Nebraska Press involved a judicial order restricting the media from publishing accounts about certain evidence that was yet to be used in a prominent murder trial taking place in a small rural community. The court articulated 3 considerations relevant to whether a restraint on speech in connection with the judicial proceeding can survive First Amendment scrutiny. 1, whether the expected publicity about the case would harm the defendant's right to a fair trial. 2, whether the gag order is the least restrictive means possible to ensure that fairness. And 3, whether the gag order will be effective in preventing the potential unfairness. At the same time, courts not only have the power but the duty to protect their processes from prejudicial outside interferences and to ensure a fair trial. Long before Shepard, Justice Frankfurter warned of a potential for trial by newspaper to tear participants from their moorings of impartiality, by the undertow of extraneous influence. At bottom, legal trials are not like elections to be won through the use of meeting hall, the radio, and newspaper. The point at which free speech and fair trials intersect in the administration of criminal justice presents serious and complex problems to those like Amici. Again, Amici is what the ACLU is calling themselves. This is the Amicus Curiae brief, who would defend the principles of both freedom and justice. Footnote number 3 here, again, just citing case law at the bottom. Nebraska Press involved a gag on the media rather than a criminal defendant. And over the past half century, courts have disagreed about whether its most demanding requirements apply in the same way to participants in proceedings before the court. Neither the Supreme Court nor the D.C. Circuit has resolved that question. Some courts have concluded that the First Amendment applies with full force in restrictions on the speech of participants in the judicial process. Even a year before Nebraska Press, the Seventh Circuit struck down local court and American Bar Association no-comment rules prescribing extrajudicial comments by attorneys on pending litigation because they did not narrowly prohibit only the comments that pose a serious and imminent threat of interference with fair administration of justice. Similarly, the Ninth Circuit has endorsed a general rule that speech concerning judicial proceedings may be restricted only if it is directed to inciting or producing a threat to the administration of justice that is both imminent and likely to materialize. And in a case with unique resonance to this one, the Sixth Circuit held that the clear and present danger test applied to a gag order restricting the speech of Congressman Harold Ford, a criminal defendant charged with mail and bank fraud. Other courts have applied less demanding standards when evaluating gag orders of courtroom participants. Some have required banned speech to have a reasonable likelihood of impairing the administration of justice. Using slightly different terms, the Fifth Circuit allows a court to restrict speech of parties and their lawyers if it determines that extrajudicial commentary by those individuals would present a substantial likelihood of prejudicing the court's ability to conduct a fair trial. That is essentially the standard the government urged the court to adopt here, pointing to a handful of similar orders it had obtained on that basis from other courts in this district. The government also suggested, without elaboration, that a lower standard was appropriate in criminal cases than in civil ones. The stricter view from the 6th, 7th, and 9th circuits is the correct one when it comes to issuing a gag order against criminal defendants. In adopting the lower substantial likelihood standard, the Fifth Circuit relied heavily on, but misinterpreted, the Supreme Court's opinion in Gentile. In Gentile, in an opinion by Justice Kennedy, the court voided on vagueness grounds a state bar disciplinary rule restricting, we don't want them to have the interpretation of Gentile incorrectly. That could not be good. Restricting attorneys' out-of-court speech on pending matters. Justice O'Connor signed onto that opinion, providing the fifth vote. But she also gave a fifth vote to an opinion by Chief Justice Rehnquist that explicitly approved, as consistent with the First Amendment, the state bar's rules standard, which permitted punishment where extrajudicial speech posed a substantial likelihood of material prejudice to the administration of justice. Justice Kennedy protested that the substantial likelihood standard, though endorsed by a court majority, was both unnecessary and unwise. Even so, in Brown, the Fifth Circuit adopted the lower standard and applied it not only to gag orders affecting attorneys before a court, but all other participants too. That was unjustified. While Chief Justice Rehnquist's opinion used some stray language that appeared to suggest his views might reach beyond attorneys, Gentile involved restrictions on the speech only of attorneys who were officers of the court. And then footnote number 4 here. Like Chief Justice Rehnquist in Gentile, the government cites a footnote in Seattle Times v. Reinhart that suggests the rights of litigants may be subordinated to other interests that arise in the courtroom. But that case involved a very different order, restricting the dissemination by a defendant, which happened to be a newspaper, of documents produced in discovery. That was not the kind of classic prior restraint that requires exacting First Amendment scrutiny. His opinion relied heavily on the history of the regulation of the practice of law by the courts, and the question before the court did not have anything to do with non-lawyers. Moreover, Justice O'Connor, who provided the fifth vote, wrote a concurrence explaining that her view was merely that a state may regulate speech by lawyers representing clients in a pending case more readily than it may regulate the press. So, in applying Gentile to parties rather than just attorneys, Brown overreached, as does the government, in urging the relaxed standard for restricting defendants' speech rights here. We have footnote 5. I have to take a tea break, everyone. All right, footnote 5. The government is just wrong when it represents that Gentile forecloses the applicability of the clear and present danger standard adopted in Ford to the regulation of speech by trial participants. It may have foreclosed that standard as applies to attorneys, but not to all trial participants. Here they're citing case law rejecting Brown's extension of Gentile to non-attorneys and rejecting notwithstanding Gentile's government motion for a gag order of parties and applying the serious and imminent threat to administration of justice standard. Here in the Carmichael case, they're saying concluding the clear and present danger standard should apply to criminal defendants. In McGregor, they're reaffirming Carmichael after Gentile, distinguishing gag orders that affect defendants from those that affect attorneys. The government also pointed to 2 post-Ford cases in district courts within the Sixth Circuit that have recognized that Gentile rather than Ford supplies the applicable standard. To the extent they repeat Brown's error, those cases were wrong, but the government vastly overstates their significance, even on their own terms. One of them concerned a gag on a sealed and classified information, a context far removed from this one. In the other, the defendant conceded the lower standard applied. So we're citing different standards here. So there's a question on whether or not the standard is being applied correctly. The obvious and unprecedented public interest in this prosecution, as well as the widespread political speech that it has generated, will continue to generate, only underscores the need to apply the most stringent First Amendment standard to a restraint on defendants' speech rights. Speech on matters of public concern is at the heart of the First Amendment's protection. There has been extensive public commentary by parties and non-parties alike about defendant, this case and the events that underlie it, and defendant's ability to speak publicly about the substance of the prosecution, even including potential witnesses and testimony, is in many ways inextricable from the 2024 presidential campaign in which he is declared a candidate. Defendant's role in the events related to his obstruction of the peaceful transition of power are relevant not only to the proceedings in this court, but to the country's decision about whether he deserves to be elected again. Similar issues were present in Ford, where the Sixth Circuit overturned a gag order that prohibited speech by the defendant, a sitting congressman, about the evidence and facts in the case, the prosecuting attorney, the government's motive in prosecuting him, and the ultimate merits of the prosecution. In striking down the gag order under the clear and present danger test, the court explained that the defendant was entitled to attack the alleged political motives of the Republican administration, which he claims is persecuting him because of his political views. It also underscored the defendant's right to express his outrage and to fight the obvious damage to his political reputation in the press and in the court of public opinion. The court noted specifically that the gag order would leave him unable to respond to political opponents who attack him as an indicted felon, or to inform his constituents of his point of view. To be sure, the government and the public have a strong interest that justice be done in a controversy between the government and individuals in ensuring a fair trial. Citing case law here. But as the court expressed in Ford, permitting an indicted defendant to defend himself publicly may result in overall publicity that is somewhat more favorable to the defendant than would occur when the participants are silenced, but would not result in an unfair trial for the government. I did skip the footnote. It was going into the Ford case with more detail, so we'll just pop over to the next page. A trial is not unfair simply because the defendant has been able to speak about it public. Additionally, as Ford emphasized, the Supreme Court's conclusion that widespread public broadcasts of the defendant's confession created an unfair trial in Shepard was premised on the defendant's right to a fair trial under the Sixth Amendment, a right the government does not have. So this is one of the key arguments between both sides. The government saying it has a right to a fair trial. The Amicus or the ACLU here is saying that is not a right that the government has. As a result, to the extent that publicity is a disadvantage for the government must tolerate it. Ouch, that's harsh. The October 17th order is overbroad and underexplained. The court in Ford struck down an extraordinarily far-ranging gag order, much broader than the October 17th order at issue here. But the order in this case nonetheless fails to justify the speech restrictions it has imposition on defendant, or to narrow that restrictions as much as possible. The court could fix that in several ways. First, The order's prohibition of targeting any reasonably foreseeable witness or the substance of their testimony effectively bars the defendant from addressing whole subjects of discussion. But witness testimony in this case will concern the events of January 6th, the results of the 2020 presidential election, and defendant's own conduct in relation to both. These topics are key points of the ongoing 2024 presidential campaign. Barring any discussion of these entire topics by defendant is unconstitutionally overbroad, and to justify even a much narrower restriction along these lines, the court must find that such discussion would actually harm the fairness of the trial. Where so many are already saying so much about the topic, it seems unlikely that silencing the defendant is justified. In any event, the order does not support that conclusion. Second, the order applies to speech that targets the special counsel and its staff. But, like the court itself, which is excluded from the order's term, the special counsel is a public official. Attempts to gag speech that addresses how the special counsel is conducting his work on the grounds of ensuring the proper and impartial administration of justice unduly undermines public discussion on matters of public concern that is at the heart of what the First Amendment protects. Respectfully, the court should exempt public officials from the coverage of its order, except to the extent that it bars speech that threatens or instigates violence against such persons. All right, so Amicus here is saying that any of the government actors should just deal with the speech that's coming out unless it's threatening or instigating violence. This is the two pieces. Now, so let me ask you this. I feel like the order was specific, stating about threats and instigating violence. But here, the ACLU is saying you need to be more restrictive, specifying only statements to the special prosecutor and their families regarding threats or instigating violence would be covered. So is this level of restriction is tighter than what was recommended? So I'm not sure. When has it not been threatening? Oh, excellent point. Excellent point. That's exactly what the court was talking about. Pretty much any of the statements that are being made are threatening or instigating violence. And this whole issue of having so many followers, and if you say something negative about a particular person, is that not instigating violence? Right. So many of his comments are threatening. Yes, exactly. So I would say they're asking for more specific language to be put in the order, but that language again would be subject to interpretation depending on what a threat and instigating violence means. All right. So I think that's a very interesting point of contention here with the ACLU and the government. Third, a key step in the court's brief analysis supporting its order was its reliance on undisputed testimony that Trump's public statements about individuals, including on merits related to this case, has led to other people threatening and harassing potential witnesses, prosecutors, and court staff. The government's motion asked the court to go even further, urging the adoption of a broad gag order, one that would even have prohibited mere disparagement, premised on defendant's knowledge that when he publicly attacks individuals and institutions, he inspires others to perpetuate threats and harassment against his targets. Amicus acknowledged the risk that defendant, who exercises substantial authority over his followers, could inspire others to engage in violence and share concerns about his apparent willingness to do so. But the First Amendment does not authorize the court to impose a judicial gag order on defendant merely because third parties who hear his public statements may have badly in their own accord, of course, may behave badly on their own accord. That's an interesting point here. Of course, where advocacy crosses the line into incitement, which is the Brandenburg test they're citing here, or where public speech amounts to a true threat or criminal solicitation, we're citing the Hansen case here, It is unprotected by the First Amendment. If the court were to find that there is a serious threat that the defendant will engage in those kinds of statements, it might justify a restraint directed to such speech, but it must sufficiently explain those conclusions and their evidentiary basis before doing so. Here's a footnote number 9. While the court made a finding that defendants' past statements used language communicating that particular individuals involved in this prosecution deserve death, the public record does not appear to reflect such language. The government's motion does refer to death threats made by other people against the court and 2 Georgia elected officials, but not made by the defendant himself. So that again is that distinction that the defendant was raising himself, and now the ACLU is saying, well, he didn't specifically make those threats. So that's another point of contention here. The mere fact that others have threatened actions against trial participants after hearing defendants' words is not enough. Finally, it is unclear that an order limiting the defendant's speech is necessary to serve the administration of justice more broadly, beyond the narrow, albeit serious, concerns of threats to participants at trial. How can they limit it to threats when they don't know it's one until it's already said? That's an excellent point, Sarah. That's a really good point. How are you going to know? So, the question is, are we doing this on the front end or on the back end? So are we trying to prevent harmful statements from being said that could lead to violence? Or are we punishing after the statements are already said? And if they've already been said, is the damage already done? So I think that's a really good question. Is it before the statement or after the statement? Which restriction is better? Which level of accountability is better? I don't know at this point. That's a good question. This case is already one of the most talked about trials of all time. There may never have been a better known criminal case in American history or a better known defendant. With that in mind, to the extent the court's order seeks to prevent future statements from affecting the impartiality of the potential jury pool, the order seems unlikely to make much of a difference. Whereas here, the order restricts the citizen's ability. Back end is way too late. Yeah, that's a good point too, isn't it? Ability to speak out on matters of public concern in the midst of an election campaign in which his words may inform the result of the presidential election. More is required than a generalized concern about further publicity about what is already one of the most public trials in the history of our nation. Conclusion. With respect, the October 17th order fails the First Amendment, and Amicus urges the court to reevaluate any court-imposed restrictions on defendant's speech. So there we have it. That's the Amicus brief. So what are we thinking here? Are we thinking that the ACLU has a good point, that the courts can issue this gag order, but they need to be more specific? Or is the ACLU asking for too much and asking for so much that we're putting witnesses and court staff and various people in danger? Or is the First Amendment freedom of speech more important than the safety of the court? I'm not sure. I mean, those are the questions to ask. Be more specific. Yeah, I'm not sure. Actually, right. Judge Chutkan was very specific in the hearing. She was, and the government was arguing that in their motion yesterday. They said, in the motion that they filed on earlier, they said, she was very specific. She said exactly what she meant. And then, you need to go forward on that, looking at the context. Freedom of speech is already confined. It's not wide open. True. Exactly. I think it's on point. These questions are on point. Excellent. Yeah, I think they're valid questions to ask. Absolutely. Judge's order was specific enough. Okay. I disagree with them. All right, fair enough. How dumbed down do they need it? Well, that's an excellent question too, because, they'd have a point here. We are setting precedent. So the next time, if someone is in a similar situation as far as, because they've only got one case with the congressman, but if another person's running for office, what level of speech can be restricted in the interest of due process and safety for the judiciary? So it's an important question to answer here, but you can say anything you want. Doesn't mean there won't be repercussions for what you say. Oh, that's excellent. That's exactly right. If anyone, true. Keep in mind, though, of course, the ACLU comes in on any case where a constitutional right is in question. They were the ones that actually brought the Brandenburg test, right, which is the very famous KKK rally case where they felt that the KKK's freedom of speech was being hindered. So they are always bringing cases regarding this. This is one of their biggest concerns. Yes, it will be cited. Exactly. It will be cited in future cases. So we've got to figure out, and that's what they're saying here. They're not saying, do away with the gag order completely. They're saying they want it to be more specific, more narrowly tailored. Meanwhile, the government is saying it's narrowly tailored enough. Everybody knows what it means. Are we going to have to wait for the harm to be done before we address the situation, or can we head it off in the beginning? Do judges tend to listen to the ACLU? That's a good question. I would say the ACLU is well respected in the legal community, but I think all of our amici typically are. We have experts on both sides coming in. So it really will depend on the judge, how the judge views the precedent cases that they're discussing here about whether or not they think the ACLU is correct or not. I don't think they have any more weight than any other legitimate organization filing amici, but it's definitely something to take into consideration. It seems very specific. Yeah, I agree. It does seem specific. And we, of course, have to have strict scrutiny with the First Amendment. So the question is, it's specific, but is it specific enough? ACLU? Mm-hmm. Yeah. I agree. He knows exactly what it means, and so does his lawyers. Right? Why should there be speech allowance at all after the speech leading to the charges? That's a good question. I think that's a fair question. There's this idea of being able to have free public debates about government and the actions going on. So a lot of that is kind of that fundamental principle of freedom of speech. It doesn't affect his free speech. Well, that's a good point too. I mean, if we're just limiting prosecutor staff, defendant staff, court staff, witnesses, and their testimony, that seems like a small group. But I think what the ACLU is saying is that it's a pivotal group, especially when included in that group are government actors, where the ACLU is arguing there shouldn't be any restrictions on speech regarding government actors, that they just need to deal with it unless there is, of course, imminent violence involved. It's perfectly tailored. Yeah, I mean, there's gag orders aren't unusual, right? They're not unusual. What is unusual is where he's at. So because he's running for president, his position in society is what is in debate, as opposed to the gag order itself. If he wasn't running for president, this wouldn't be an issue. This would just be a normal gag order set out and accepted under the terms. But here they're saying because he's running for president, we have a unique situation where he should be allowed to defend himself in whatever way he thinks is appropriate. Trying to fight the idea, not a specific case. Good point. Very good point. And that's why the precedent here can be flipped both ways. The ACLU is arguing the government's view on the precedent case in Gentile is incorrect. And the government is saying, no, that's not what Gentile says. So there is this fundamental question on the interpretation of precedent. That is the role of the U.S. Supreme Court, to make determinations on which way the precedent falls. So that is one of the pieces to be issued or to be dealt with on appeal. This would only be applied to people running for office. Suze, I think that's right. I think this would only be applicable. That's what the Gentile case is about. That's what the Ford case is about. Has to do with attorneys being able to speak as well as someone running for office. Those are the scope of the cases that are in question here. So I think that's really the key element. Not even someone who's in a government position, but someone who's actually running for the government position by being able to run and being able to defend themselves while they're running, because that kind of speech is necessary during the process of campaigning. Heavily on dog whistles to his supporters. You can't get more specific. True. I mean, that's another excellent point that the government's brought up, is saying, hey, his supporters, every time he says something, his supporters make a move. Meanwhile, the ACLU is saying, well, that's his supporters. That's not him. He's not specifically saying it. How can he be held responsible for the actions of third parties? That's what the ACLU is arguing. Oh, I don't know that the ACLU is corrupt. I don't think we can throw everything out the window. I don't know about that. I think everybody has, their own perspectives, their own view on what's too much or what's not enough. And they're just presenting their side. Oh, my goodness. They're just presenting their side. The ACLU is not always correct, but they're also not always wrong. The ACLU goes back and forth depending on the situation. There have been multiple cases where I have disagreed with the ACLU. In other situations, I felt like, yeah, that's fighting the good fight. So, just like any other organization, one way or the other, they can be right and they can be wrong. They can be both. Yes, well, the ACLU, I can't believe the ACLU is involved in this. The ACLU is involved because it is a First Amendment case. If the First Amendment's involved or any kind of fundamental right, the ACLU is going to step in. It doesn't mean that, they're bad people. It just means for them, their scope is, with the First Amendment is huge. They would prefer almost no restrictions on the ACLU, on freedom of speech. The ACLU would disagree with any kind of restrictions. So when it comes to pornography, defamation, those kinds of things, they're going to really be frustrated with that. Even though those laws are already in place, they would fight for their restrictions. That's just kind of their job, because they're trying to keep the civil liberties as broad as possible. So it just, in this situation, again, they're saying you're putting a restriction on the First Amendment. We don't like it because we don't like any restrictions, pretty much. So we're going to go forward and give you our opinion of it. Imperfect, not corrupt. Yes. I mean, they argue for what their beliefs are, right? So many of their beliefs, I personally, I'm like, sure, I can get on board with that. But sometimes their beliefs are too much. I think the ACLU goes too far. I believe lots of organizations go too far. It's possible for anybody to do that. Now, in this case, I'm uncertain. I will need to look through the precedent here. I will need to reread the Gentile case and the Ford case in order to figure out my own personal stance on the restrictions here. So I'm undecided as of right now. But sometimes they get it right, sometimes they get it wrong. Why didn't they argue this in New York? I think the biggest difference, great question. The biggest difference is because this is a criminal case. The New York case is a civil case. So the restrictions are different. Anytime we're dealing with a civil case, the worst that'll happen is a loss of money, loss of business. But in a criminal case, it's your loss of freedom. And that true loss of freedom is really what's at issue here with the First Amendment. So because of that, I think that's why they've not necessarily stepped in New York. I think if any of the other criminal cases start to put in these kinds of restrictions, they will come in again with it. Has the judge received the brief? Yes, this has been filed, but we do not know if it's been accepted yet. Do you think this argument was overwritten? I don't think so. I'm not surprised it's come in. Again, we're just in unprecedented times. We've never had a presidential candidate before being prosecuted criminally, threatening witnesses and the court staff. Typically in the past, when cases have involved high-ranking people, and they go through the process, they say, justice will prevail, or I believe in justice here. And so they leave the court staff alone. But we don't have that in this case. This case is unique because the defendant is not giving any credit to the judiciary. The defendant is the one attacking the system and claiming the system's corrupt. So that kind of language is something we've not dealt with when we've dealt with someone at this level being prosecuted. What does accepting the brief mean? Okay, so friend of the court, again, is an impartial party, so someone who's not a party to the case, who's offering opinions and thoughts, research, and law to support a particular view on the issue in the case. So in order to file an Amicus Curiae brief, you need permission. This is an appeal. So this is the District of Columbia. This is a trial court, and we have an appeal that's gone up to the circuit court, the federal circuit here. But if we're dealing with the United States Supreme Court, they take Amicus Curiae briefs all the time. But this is just a trial court. It just happens to be at the federal level involving a First Amendment question. So in order to actually have their case heard, their brief heard or listened to, they need to get permission from the court, because the court might say this is an inappropriate brief, or this isn't the place and time for you to file this brief. Those kinds of questions have been pulled up in the Georgia case. Those amicus questions have been pulled up in the Florida case. So in all of these different district courts, so these lower level courts, don't tell them I called them lower level, but you need to get permission before you can file these kinds of briefs, because you're not at an appellate level where it's automatically assumed that an amicus brief would be allowed. So that's what I mean. I mean, they have filed it, but the court may come in and say, this isn't the right time and place for this brief. I appreciate that you have points of view on it, but we're not at the point yet where an amicus brief is appropriate. So that's what I mean by that. Mm-hmm. Secret's safe with us. Yes, so this is the interference with an official government proceeding case and interference with civil rights. So this is the 4 counts out of the DC case where we've only got one defendant. He always claims political movements. He does. And he seems to have some success with that along the way. Yeah. Can we sue him for emotional distress? That's a really good question. Now, the emotional distress has to be kind of targeted. So that's the thing with emotional distress, is it has to have a particular person. Anyone who feels kind of like they've been harmed emotionally in general, unfortunately, is not going to be able to necessarily succeed on an emotional distress claim. It needs to really be targeted. That's why we've had some of the police officers, some of the representatives who have been suing based off of the January 6th situation, and they're allowed to go forward on a lot of the different pieces, but emotional distress is not one of them because it was not specifically focused on them. Most of the American citizens, yeah, I think so. Class action, emotional distress. I think a lot of people feel that way. I think a lot of people feel harmed here and are unsure how to get any kind of accountability or kind of get back to where we were before, which is the point of the whole system. I think a lot of people feel that way. Yes, Suze, exactly. I mean, who should pay those kinds of bills? Who should be taking care of the medication or taking care of the loss of work because of the overwhelming feeling of, dread? Who should be accountable for that? That's a good question. We'll see. Yes. Now, have the 2 women in the election workers sued Trump for emotional distress? Now, great question, Angela. Those election workers have sued for defamation and have won. They've not specifically included Trump in it because the statements themselves, they've gone through Giuliani. And I think that was wise. I think if you can get to the crux of the issue without having to pull in the media circus that is Trump, I think that's definitely the better way to go. in this case. But they did not go forward on Trump. They did go forward on Giuliani, and they were successful. Which honestly, if they wanted to go forward on Trump with having that finding of fault on Giuliani, their case would be stronger now if they wanted to go forward and file against him. Yes, they did. They did win. It's the main source of defamation. He was. Although, while they were testifying in front of Congress, they were saying that when Trump tweeted out their names, that's when things got really bad. So could that one tweet be seen as a level of defamation that would allow them to go forward on a suit? I'm not sure. It's possible, but I'm not sure if it would be enough. If he goes to jail, can he run again? Technically, yes. Yes, there's nothing in the Constitution that prohibits anyone who has been convicted of a crime from running other than treason or sedition. We do have that 14th Amendment Section 3 issue in front of the court in Colorado, and that's huge. Also, Minnesota still has a case going there. It's looking like Michigan will probably go forward as well. So we do have that disqualification clause under the 14th Amendment that's being debated. Should probably change that. I agree. But we can't agree on anything right now. We can't, I think I've said this before, we can't even keep the lights on in Congress, much less agree to change the Constitution. We're just too far, we're too far away from each other at this point. In time, I think it's important, but criminals can't vote but can run for office. I know, it's a problem, isn't it? I mean, it's a fundamental issue, a flaw in the Constitution. For sure, I agree. Is Trump allowed to continue to have fines only, or is there a cap where he'll be charged criminally? So another great question. In the New York case, he's been fined, as we know, a couple of times, but it's at the discretion of the judge. The judge has not had a finding of contempt yet. He has fined him, but there's not been an official finding of contempt. If there is a finding of contempt, the judge can go forward and put into place some jail time. And I think, honestly, that we may get into that area. We may have a couple more fines issued, much bigger fines, which is what's happened in the past. So I'm basing this on fines where he was fined $10,000 a day, I think, for sanctions for a week based off of his attorney's actions in the previous filings in New York. So he was fined 10 grand a day for multiple days. So I'm not sure how far this judge is going to go for the fines, but there's really no cap. It's just at the point at which the judge has just had enough and has to say, basically, like you would to an unruly child, at what point does the punishment make it so the behavior changes? That's kind of the fundamental question here. And is jail what's going to make Trump come into the rules, come into what he needs to do? I'm not sure. Would fines? Well, we all know how he feels about money, so there is that issue going on there as well. What is Trump's currency? And that's what the judge has to find. They have to figure out what's so important to Trump that if they took it away from him, he would stop doing the bad behavior. That's ultimately what they have to figure out. Right, he was born with contempt. He did pay. We do have actually a check. We do have a check on file now, officially, that shows he did pay. And he did pay the court in the previous case, too, where he was fined $10,000 a day. So just to remind everybody, we do have a check on file here. Yep. Nope. It just came through. So this is kind of, unless you're watching the docket, you probably wouldn't know. He paid with campaign funds. All of his legal stuff is being paid through PACs. And people are donating money that they probably don't have and putting it into the PAC. And legally, they can do it at this point. Did they successfully cash it? That's the question, isn't it? I don't know, because it's from the trust account out of the law firm. So they could be in some serious trouble if they didn't have enough money in the trust fund, but who knows? The trust account. It's sad to watch this. I agree. It's heartbreaking. It's, if you look at the state of where we're at here, where we've got a former president indicted and people who are, unable to really acknowledge true facts and evidence, it is sad. It is sad. But it's also academically a fascinating time in the legal world. So I try to look at it from that perspective as opposed to the sad state of someone giving their Social Security and disability money to a PAC to pay for his legal fees, because that's too much. That's too sad. It's been an interesting show. I agree. This is not his money, so it does not hurt him. Well, that's the thing. How far do we have to go? How much money does it take in order for it to be hurt? In order for him to feel that? Again, that's finding the currency, finding what level it takes in order for him to come into compliance. That's the court's job. I mean, you've got to follow the court rules. It is eye-opening for sure. I agree. Yes, we're kind of wrapping up now, Kim. His currency is ego. That's true. And I think, if you think about it too, when the judge called him up to testify and then blatantly said, "I don't believe you," it seems to me like in that moment, that would have had an effect on Trump. And I believe it did, which is one of the reasons why he stormed out later. But those kinds of statements where his integrity is being questioned, I think absolutely is something that is a check on him, literally, because his integrity is being questioned. So the judge may be onto something in that situation where the judge is actually calling him out in front of everyone. I think that's going to have more of an impact than, a $5,000 fine. He straight up lied on the stand. Well, according to the judge, he felt that. He felt that he did. Did Judge Chutkan decide to open the possibility of camera in federal court? So in the DC case, Judge Chutkan has asked for briefs. She's asked for the opinions of the defendant on how he feels about it. So those briefs are due next week. And that statement, those responses are due. So once she gets that, she will contemplate, probably set it for a hearing, and then make a decision after that. Very much not a credible witness. He's got some credibility questions. Affect his confidence to lie under oath as well. Perhaps. Judge called him out when he said he won 80% of the case too. Exactly. So that's the thing about the New York civil case. The judge there is just, he's been a judge forever. He has so much experience with these kinds of cases. He knows the law. He knows his authority. He has so much experience. He knows how far he can push it. And at this point, he's like, I'm just trying to get this done. I'm not here for the publicity. I just want to get this case done. I've already ruled, but, we've still got some more issues to take care of, so let's get it done. So he's not going to dink around. He's going to say, look, I gave you an order. You need to follow the order. And that's really hard for some people who are never held to account. It's really hard when they get an order. But, the courts have the authority to order you to do stuff. It's a lot. Too bad the court couldn't force him to wear. Oh my goodness. I don't know. Yes, Daisy, I think that's correct. I think he does have Trump's number. I think so. Did you have all of your past videos on YouTube? So I'm a little bit behind on posting. I do have a lot of videos up, but I am a little bit behind. I've got 6 now actually waiting to be posted. So I've got them staggered out. They will be getting posted over the next week, but I'm a little bit behind. I'm trying to get them posted as quick as I can. I need another 2 of me, I think, in order to keep up. There's so much going on. Are you doing better now? I am doing better. I am feeling much better. I needed that little bit of a break, but I am doing better. I'm so glad to be able to come back. Very happy about that, to be able to share all the information. There's just so much going on. So it's been very fun. definitely is in need of a contempt charge. Fines aren't working. We'll see what happens. The judge set it up that way with his last order for his $10,000 contempt, or not contempt, but his $10,000 sanction. The judge set it up and said, hey, you know what? You might be held in contempt of court. You may need to go to jail next time. So he did set it up. 2 days felt like a week. I know. I know. Oh my gosh, I agree. Your health is more important. Yes, I know. I've got lots of people taking care of me nearby, so I'm very thankful. I've got a lot of people watching out for me and taking my pens away. That's the big thing. If they take my pens and my highlighters, I'm just completely immobile. So if they hide my pens, I'm done. So I have to take a break until I can get my pens back. They take my pens and all my highlighters. It's so funny. I've got this this is my little box, but I've got big boxes of all of my pens and highlighters, and they take them from me. Or they'll turn the printer off. The other day, one of the people was like, printer's off, you can't print. Oh my gosh. No, not pens. That's funny. Yes. So I've got wonderful, amazing people in my world helping me out. Called the ACLU. I should. It is love. I'm very well taken care of. Will you do another Hawk Live? Absolutely. Hawk and I will definitely be back to another live at some point, for sure. We've got lots of great material to go over. So, oh yes, they do know how to make me rest, for sure. Yes, turning the printer off. I know, right? Some people have other ways of making people do stuff, but for me, you take my pens and my printer and I'm done. I'm basically just like a beached whale at that point. Oh, it's fun. We'll get the split screen. Yes, I'm doing some research on that for sure. I've got to make that. Yeah, take your toner. No, not the toner. You found Court Listener. Oh, I love that. Excellent, Caitlin. That's going to be a great resource. Yes, so Jennifer Hawk is another creator here on TikTok. Very fun, interesting creator. So we'll definitely be back again to do another live sometime. We'll see how his schedule goes as time goes on, but yes, Barrister. Yes, I do. I was on a live with him just last week, actually, for just a little bit. I just kind of popped in and very, very informational. Lots of interesting, fun points when he gets a group together, and they've got some great points. And Legal Dad, of course, is also a wonderful resource. So very, very enjoyable. They promised to invite me to Las Vegas next time. We'll see. I asked him, I said, you guys didn't invite me. So we'll see. But very lovely, great creators, very smart. And their insights are just so interesting. I think it's always great to get lots of different opinions and lots of different perspectives on things. So I'm very thankful for the content. So let me borrow the check. I don't know. This one's been filed in court. So, but we do have proof. So really, Glenn. Okay, that's good. That's good to know. I should write that name down real quick while it's here. So I might take a look as well. Yes. I think I know who he is. The name Hawk and Barrister. Yeah. So this check was for the fines. So Trump was fined twice for his out of court statements. So Glenn Kirshner, is he the one that is the justice guy? He's got a tagline that's like justice for everyone or something like that. I'll have to remember. MSNBC. Okay. Yes, Justice Matters. Yes, that's it. That's it. Okay, yeah, I remember. I remember. He's also on a couple of different YouTubers. Excellent, excellent, excellent information from a trial attorney, and he does great work too. So he's been great. Yeah, because Justice Matters. That's right. That's right. That's what I thought. Okay. Yes, he does great work as well. So I've definitely enjoyed taking a look at him, for sure. He's got such great information. But this check was for the 2 violations of the gag order. We had a $5,000 violation and a $10,000 violation. So they combined it and sent this check in just a few days ago. Would you ever do any show? I might. I don't know. I might. I'm shy, everybody. I'm pretty shy. So I don't know. Maybe we'll see. We'll see, but I'm not sure. A bad check from Trump. Well, you do just as good. Oh, that's so sweet of you to say. I appreciate that. Yeah, I mean, I think we all have our different ways of looking at things. So you're the best. Oh, that's so sweet of you to say. Oh my goodness. Oh my goodness. You keep better records than Trump's lawyers. Now that I'm not going to disagree with. I shouldn't say that, but I did work as a prosecutor. I am a bit shy now that I think as you get older, it's not necessarily that you're less bold. It's just you've just don't find the thrill that was once there by going out and jumping into the spotlight. I don't mind just being in my little quiet corner of the internet. I'm pretty happy here. So we'll see what happens. Oh, yes. I'm happy to be here, but it's also nice to just to just hang out. So extraordinary. Oh, thank you so much, Blue. Yes, the little corner here where we can all just hang out and talk about the law, and we don't have to worry too much. So I've been enjoying it for sure. Yeah, he got 34 felonies. Yeah, there's a lot. There's a lot going on. There's a lot to unpack with all of these cases. So I love this corner. Oh, that's so sweet. How's the check real? Right. So this is the organization that the judge ordered them to pay. So the Fund for Client Protection, all states have this fund where we've got a client protection fund in case there are issues going on. So this is kind of a charitable fund for the justice system. So that's where they were told they needed to file it for. So George Santos, I know. Oh my gosh, that person's got some issues. He's got some things going on. So I like the memo line. Yeah, contempt fines. I know. Well, we're specific too. We don't want to make any mistakes. Oh, we enjoy being on this. Oh, I'm so glad. I'm glad. Yeah, I had no idea other people were interested in this until people started coming by. I was like, all right, let's talk about it. It concerns me mentally. You're not alone. A lot of people feel that way. Oh, for sure, for sure. Well, I'm going to go ahead, everybody. I'm looking at the clock here. I'm going to go ahead and sign off for now. It's been a very fun, quick live this morning. Oh my goodness. I will be back. You make it fun. Oh, thanks. I do try. It can get a bit dry at sometimes, but so I will be back again. Now I'm going to be carving pumpkins tonight, so I won't be back tonight, but I will be back up very shortly. Maybe not today, but I will be back tomorrow. I'm not sure exactly what time, but keep your notifications on, and then I will be back to my regular scheduled time, weeknights, which is 7:00 Central Time. So I will be planning to jump right back in Monday to my normal schedule. We've got lots of stuff going on, so we'll have lots to talk about. I'm not thinking that 1 p.m. is going to actually work today. It's possible, but at this point, I don't think it's going to work. I'm going to need a little bit more of a break than that. So for sure tomorrow, I will be back. For sure tomorrow. Acting up on notifications. Okay. So tomorrow I'll absolutely be on. I don't think I'm going to be able to come back on again this afternoon. I had planned earlier, but things just didn't work out quite right. So no calendar. I know. I need to get the calendar out. I need to update the calendar. So I'll do that. I'll do a check-in. I will plan on this same time tomorrow. Hopefully this time works okay for everyone, but 11 a.m. Central tomorrow, I will be back on and I'll kind of give everyone an update. I'm also going to do a post on what my next lives will be because I've got a lot of material outside of the Trump cases that I would like to go over. So I'm putting together a schedule for the live calendar for this week and I will be back tomorrow. Yes, Deborah, good to see you. Good to see you. But for sure, I will be back. Now, I will say, as a quick side note, I am planning, after I get back from carving pumpkins, I'm planning to do a live tonight, which is my sub chat only. So this is just a special time that I set where anyone can hang out and listen. I've got something that's not a Trump case, but another legal issue I'll be going through tonight. Just a short live later this evening where I've got my subscription only chats on, just as a thank you for people who are subscribing. You certainly do not need to subscribe in any way whatsoever, but this is just a little way of saying thank you. I was unable to do my sub chat only last week, so I'm going to go ahead and do it tonight. So I will be back tonight for sub chat only in the evening hours. But for everything else, I'll be back at 11 tomorrow Central. And of course, I will, you do not need to subscribe. Again, everyone will be able to join me anyway, but I'll just have my sub chat only on as a special thank you for everyone. So can you cover one of your cases sometime? Oh, that's a good question, Kristen. I'll have to look through my files because I've kept them all. I'll have to take a look. So, all right, everybody, I will sign off for now. I will see people in the sub chat later tonight. Tonight it'll be probably about 8:30, about 9 o'clock Central Time tonight. So for anyone that wants to swing by. But other than that, I will be back again tomorrow, 11 Central, and we will be back on track again, and I'll get my calendar set up. Yes, I will be carving pumpkins later, so I'm looking forward to it. Thank you so much, everyone. Thanks for coming by. I appreciate it. Have a fantastic day, and I will catch you all again later. Take care.